State of Florida. We'll start off with court.
Good morning, everyone.
Good morning, Your Honor. My name is Evan Langbein, and I appeared here for the appellant, Joseph Assaf. We asked the court...
Want to save a couple minutes for rebuttal?
Yes, I do. Thank you for reminding me, Your Honor. 4 minutes.
4 minutes.
Yes, if I could. Thank you for reminding me. We asked the court in this appeal to reverse an attorney's fee judgment of almost $33,000 against Mr. Assaf. I'd like to read one sentence from Judge Fulmer's en banc opinion in the Neat versus Cypress Club Condominium case at 718 Southern 2nd, 390, and the page I'm reading from is 393, decided, I believe, in 1997 or 1998. And he stated in that opinion, one who defies the statute, and the statute he's talking about is Florida Statute Section 718.1255. One who defies that statute and files in court without first submitting the dispute to non-binding arbitration.
What happens when the dispute involves injunctive relief?
Injunctive relief. The language of the statute, Your Honor, almost states that every case that goes to arbitration is a dispute that entails injunctive relief. Because what the statute deals with disputes involving the unit owner's unit where the association seeks to compel the unit owner to take some action. That's a mandatory injunction, I believe, or to refrain from taking action, which is a restraining order. So now there are some injunctions that are specifically excluded from the statute. Evictions, assessment issues, fiduciary duty issues.
What about a construction issue that could involve a situation that might deteriorate? A leak, for example. Leaky windows, leaky roof, where someone needs to get into the unit to inspect it, to remedy the defect or the problem.
And if access is denied, that was this case. It was an access to unit case. If entry is denied, you file a petition and $50 filing fee with the Florida Department of
Justice. And you have to go to the ombudsman, and you have to have your arbitration or your process before you can go file your lawsuit.
Correct.
You're arguing that even in an emergency situation, you'd be required to go through arbitration rather than to seek a temporary injunction?
The statute has a provision. In fact, opposing counsel quoted the provision in his brief that specifically says, if it's an emergency, you file a petition with the department, with the administrative agency, and you ask for the agency to abate the action so you can take the emergency to court. And in fact, that's exactly what happened, Your Honor, in this court's Nine Island decision that Judge Lagoa authored. What happened in that case is the association complied with the law, and they filed for arbitration, and they filed a motion to abate.
But in this particular case, there wasn't even a request for arbitration until approximately a year after there had been litigation in the case.
That's right.
And only in a motion to dismiss. But it wasn't pled, it wasn't requested. There were numerous instances where you appeared before the trial court and never raised the issue of arbitration. The tower is really claiming that you waived it.
But it's not. It cannot be waived, Your Honor.
No.
It cannot be waived.
You're saying there was arbitration. Your right to arbitration cannot be waived.
Cannot be waived, and let me explain why. Number one, Florida Statute 718.3032, that is quoted in our brief, states a provision of this chapter, and it's talking about Chapter 718, which is the condominium statute, may not be waived if the waiver would adversely affect the rights of a unit owner or the purpose of the provision. The purpose of the provision was that the legislature recognized as a matter of public policy, and I'll get to a case called...
Well, let's talk about that. It says if, and that's the important word in your argument, if it defeats the purpose. If litigating the case for a year wouldn't that defeat the purpose of arbitration, which is to resolve the issue quickly without going through the litigation? But if you've already litigated for a year, wouldn't that defeat the purpose of arbitration?
They pled in their complaint that they had complied with all conditions preceding. Mr. Assaf, for the first 4 or 5 months of the case, was pro se. He didn't know about the statute. And even as lawyers...
Mr. Langbein, I'm not sure that there's a different set of laws for people who are pro se and people who are represented by counsel. So, having to raise this right away was incumbent upon him, as it would be had he had counsel.
But see, the statute deals with a public policy issue. As Judge Salter recognized in his Ocean 2 opinion, Ocean 2 versus Kligger, the unit owner, and the legislature stated this in the statute, a unit owner in court is at a decided disadvantage against the association, both economically and otherwise. In this case, it was economics. He was disadvantaged, and he also was disadvantaged in the sense that he didn't know the law.
Isn't Sterling out of this court essentially on point for this issue? In Sterling, this court held that because the parties had litigated in the circuit court, and in that case it was for 2 years as opposed to the 1 year in the instant case, but says the intent of the statute would not be furthered by compelling arbitration, would in fact be contrary to the statute's stated intent.
Well, our position is...
And it says that he actually waived his right to compel arbitration. So here's that this court has already found that you can, in fact, waive your right to arbitration if you pursue litigation over a period of time and you don't request the arbitration, that you waive it.
Well, Sterling was decided before Meach, and Sterling dealt with a motion to stay, not to dismiss, a motion to stay the court case pending arbitration. Another distinction, a big distinction in the Sterling case was that a counterclaim had been filed and was set for trial by the party who then sought to go to arbitration and have the case stayed. When Meach was decided the following year, the landscape changed. It effectively overruled this court's opinion in Sterling.
Oh, well, I disagree with you. I don't think that it in any way overruled it. The facts are quite different. But I mean, in Sterling, this court looked at what the intent of the statute. It says the intent is to keep the costs down, to avoid delay, and so on. But if you don't request arbitration and you litigate the case, and then a year later want to arbitrate, you've defeated the purpose of the statute.
Well, again, we say you cannot waive, in Ashbury Arms versus the Department of Business Regulation, which we cited in our brief, which was decided before Sterling, the court, and that was a condominium case involving the 15-day boardability provision of Chapter 718. The second district in Ashbury Arms said that when you're dealing with a right that is both a matter of public policy and individual right, the individual cannot waive the statute, cannot waive the provision, because it deals with public policy. And this statute deals with public policy.
If you want to save your rebuttal time, I'm sorry to
Okay.
interrupt your question.
Thank you.
May it please the Court, good morning. My name is Joshua Spector, Coleman Bahamas counsel for the appellee Tower 1800 Condominium, Inc., which I'll refer to, please, the Court as the association. Your Honor, the only argument that we heard in the primary argument of the appellant is or regards the merits of a motion to dismiss that wasn't even adjudicated by the trial court below. We haven't heard any argument, and frankly, the briefs do not put forth a compelling argument as to why we should even get to those issues. Because the key issue here, the threshold issue, the linchpin issue for this entire appeal is whether the trial court properly entered the order striking Mr. Assaf's motion to dismiss as a sanction for discovery violations. Mr. Assaf, and the Court is well versed with the briefs, I don't need to reiterate the facts, but just to highlight two, Mr. Assaf missed 2 depositions and failed to comply with the discovery order that set forth an order for the taking of depositions in the case. That, combined with other factors, led to an order granting sanctions. So the scope of this Court's review is whether a discovery order was properly entered below.
So we're here on a fee award, correct? We're talking about a fee award here.
Well, the fee award is also an issue, Your Honor, and
it stems from what? Why is there any issue about a fee award? What order are we talking about to which we're discussing fees at all? There is discussion of fees in this. You're saying you're talking about the wrong motion. You're talking about the wrong order. You should be talking about a different order, an order striking as a sanction. Is that what you're saying?
That's the key issue with respect to the motion to dismiss, Your Honor. The motion to dismiss wasn't adjudicated, so to the extent that this court is reviewing the case below, with regard to...
That's not really the issues that were raised by the appellant in this case. I mean, as I understand it, the issues that were raised by the appellant is he was claiming that, first of all, he had the right to arbitrate, couldn't be waived, and secondly, that the trial court should have ruled on his motion to dismiss prior to taking any other action in the case, and that the order submitted by the trial court regarding insurance fees did make the requisite findings. So those are the issues raised on appeal, not whether or not he should have had his case dismissed or his pleading stricken because of discovery violation.
Well, that's absolutely correct, Your Honor. But for those very reasons, we feel that the appeal misses the mark. That arguing the merits of the motion to dismiss aren't material to the issues before this court, whether the fee award was proper, as Chief Judge Wells has addressed, and on that point, the record, to the extent that it's before this court, shows that there was an evidentiary hearing held with live testimony with an expert witness, and that the trial court made findings there. That Mr. Assaf appeared at the hearing and defended his interests. That's the extent of the record, Your Honor.
Well, but his argument is that once you obtained the relief you sought, which was access to the free apartment for inspection, that the lawsuit was over, and yet there was continued litigation that increased the attorney's fee. And so that's what his argument is that it became moot after you were granted that access to inspect the apartment.
Well, to some extent, the appellant was right in the sense that the case was over at a point, Your Honor. We got access. The trial court entered the injunctive relief early in the case, and then the association moved for summary judgment below. It was entered. It was Mr. Assaf that reopened the case, introduced new evidentiary issues, affidavits from witnesses who also never appeared for depositions that were duly noticed and scheduled, and it was because of these new issues and Mr. Assaf's claims for attorney's fees that caused this case to continue. We didn't keep beating a dead horse, Your Honor. There's sports analogies in the briefs. And
there are therapy and counseling analogies in all of this, too, between the condos. Why isn't that a perfect case to require arbitration before hammer goes to tongue and condo unit owners and associations just battle it out?
Well, Your Honor, in this case, I think the record and the briefs will give the court sufficient detail of the difficulty that the association had getting an emergency inspection done by its engineer. It faced a fine of $1,000 a day. It faced possible condemnation and greater issues of health and safety that affected the entire building. Mr. Assaf was the only unit owner that didn't permit inspection. Why? We still don't know. And how he's going to prevail on his right to go back in time and have precluded access and somehow win below is beyond me, and we don't see that in the arguments or in the briefs. So it's unfortunate that there was this much work, but frankly, that was the fault of the appellant. His intransigence, his discovery misconduct, the number of hearings filed, number of motions, and the relief sought by him, including...
So really your position is this public policy argument is a red herring. It's a red herring because the emergency relief was sought. Perhaps there should have been some arbitration or mediation there. The emergency relief was granted. It was all over. The municipality was done and over with it. Then Mr. Assaf comes in on his own and seeks affirmative relief and then refuses to engage in any discovery. He didn't demand arbitration or anything else of this. And now we're way down the road and this case is over and attorney's fees have been awarded to the municipality and Mr. Assaf is complaining about the public policy, and you're saying that's just a red herring. It has nothing to do with any of this.
That's correct.
That's your argument?
That's our argument. That's our argument. He's in a mess of his own making. The record's very clear about the difficulty that the association had dealing with him below. The trial court made
opposition. But if his complaint was that you all did not follow the mandatory statutory requirement to engage in some kind of non-judicial dispute resolution before you triggered this lawsuit, why wouldn't he be entitled to? He would be entitled to prosecute that. That's why he reopened. Well,
again, Your Honor, first of all, we disagree that issue is properly before that court. That's the merits of a motion to dismiss that wasn't adjudicated below. But frankly, he's wrong. He's simply wrong on the arguments that found the motion to dismiss.
Okay, and that was all short-circuited because he instituted that and he wouldn't play the discovery.
No,
he wouldn't comply with discovery, so the court said you're done.
No, Your Honor, that's actually not the issue. For several reasons, the motion was just wrong-headed. Number one, this court's prior precedent in Sterling, just as Judge Rothenberg pointed out, is a controlling precedent. It's got analogous facts, and it regards waiver on similar circumstances. There was no counterclaim here, but there were claims for attorney's fees. There was discovery propounded by Mr. Assaf in the circuit court.
So as in any arbitration, that participation in the judicial process would be a waiver of any rights you had to arbitrate?
In this case, under Sterling, yes, Your Honor. I don't want to make a categorical statement of that, but on these facts and on the island that's set out and defined by Sterling, that is the case. But, Your Honor, if you look to Section 718.303, there is a carve-out for injunctive relief in the court, not in arbitration, but in the court, and there's specific references to court determinations and litigation and actions for injunctive relief for violations of Chapter 718 of the Florida statutes or bylaws of a condo association. Those are the two counts that were brought by the association below. That's permitted injunctive relief under Chapter 718.303. The waiver issue under Sub 2, as I believe Judge Rothenberg's questions were touching on, that's been decided by the court. You can waive arbitration, and it was done here. But specifically, Your Honor, under this statute, the conditions preceding and so forth were properly met. You can start with injunctive relief on these narrow claims.
Thank you.
For these reasons, we ask that the decision below be affirmed and please award the honor. Thank you.
Thank you. Rebuttal?
I'd like to address Judge Rothenberg's question, Mr. Spector. They had more or less conceded, both in their brief and again in Mr. Spector's argument, that we were right in saying that the case was essentially over 28 days after it was filed. They got access, which is why they filed. They got access to and they inspected it, and basically there was nothing else to do other than seek fees. And what should have happened, in my view, at that point, he shouldn't have even filed, when I say he, the trial counsel for the association, shouldn't even have filed a first motion for summary judgment, which he filed, I think, 13 days after the inspection had been granted. He shouldn't even have done that. He should have simply set a motion.
The problem is that the trial court had an evidentiary hearing July 2nd, 2009, and granted the association access to these units. And almost immediately thereafter, December 1st, 2009, Mr. Assaf then began to propound discovery and to seek other relief. It should have been done at that point. And when he started, pursuing discovery, then failing to appear for depositions, that's when this whole thing mushroomed.
Well, my point is, Your Honor, that we moved for rehearing of the summary judgment that was entered in 2009.
Correct. And
that summary judgment was all about attorney's fees. I mean, because there was nothing else to rule. And it awarded $13,555 in change. And that's when Mr. Cinnamon, by the way, I neglected to introduce Jeff Cinnamon as the lawyer sitting next to me who handled some of the case below, and I apologize to Jeff and to the court for not introducing him. But Mr. Cinnamon came in, and his first order of business was to move for rehearing. And then the Condominium Association, through its lawyer, came to Mr. Cinnamon and asked to vacate the judgment because there was an affidavit was attached, for instance, by the bookkeeper for the Condominium Association that said they didn't even need to file this lawsuit in the first place because they have the keys and they could have just accessed it at a reasonable time. That's what the statute says they can do. They didn't even need to file a lawsuit. They filed a lawsuit because for political reasons. These people were the board of directors of the association were feuding. Mr. Assaf was trying to unseat the president.
But the problem with raising all of this at this late date is, I'm not even sure if you read the Condominium Act that the provision that you're relying on applies to this circumstance. And that's the problem. We're way, way down the road, and this issue's being raised way down the road. I'm not sure this provision is even applicable in this case. Because the condo document itself, there's an express condo document here that gives absolute access, and there's provisions in the condo law that address those provisions. So, this is like an argument that's made so far down the road that it's difficult to assess its applicability here.
Well, I think the argument under 718.303 was simply eradicate 718.1255. It would eradicate it. It would say, because everything's involved in the bylaws, and so then the statute was meaningless. The legislature passed a meaningless law. And I don't think that was, if you read the legislative intent of that statute, I think the court is duty-bound to give it the broadest reading and the most liberal reading that you can to try to get as many cases into arbitration. I think, as Judge Salter said, this case inherently belongs in arbitration first. And we attached as a supplemental authority, Your Honor, the case of St. Andrew's Condominium Association versus Geist, which is an opinion of an arbitrator with the Department of Business Regulation that dealt with an access to unit issue. And you can go online and look at some of the written opinions of the arbitrators. A lot of their orders are reported in Lexis and I presume on Westlaw too. And you'll find out that there are a number of access to condominium issues that have been arbitrated since this statute went into effect 20 years ago.
Well, 718.303, I think could be argued is the one that applies, and it says injunctive relief for these kinds of things that in the condo document is available. It doesn't say you can do anything else first. Well, injunctive relief, and it's a statutory provision as well. So,
but you have two conflicting statutes in the same act, then, which probably can happen when you come along later. The condominium law went into effect before the early 1990s. I think it goes back into the 70s. And this statute that we're talking about today, 718.12, was the present version of it was 1991 or 1992, as the court explained in the Meat decision. So,
and you'll wrap it up?
Okay. We ask, I really unfortunately didn't address the inadequacy of the attorney's fee order itself, which had none of the woe findings in it, and really based on it's facially defective and should be reversed if for no other reason, that reason.
All right. Thank you.